Hi there, and thank you for tuning in. If you were enticed to tune in because of the trailer, we just hope this is not one of those instances where the trailer ends up being much better than the final product. In this first discussion of the Discussion from Home series, we will be covering the currently popular topic of virtual arbitration. We will be sharing our experiences with virtual arbitration and then delving into questions such as what are the hassles and difficulties that users might face? Would virtual technology enhance diversity in international arbitration? What about the clients? What do they want? How about issues such as confidentiality and guerrilla tactics employed by counsel? And can we expect an international convention on virtual arbitration in the future? We really hope that you find this discussion interesting. And without further ado, let's move to it. We are five young lawyers frustrated by the numerous webinars that have been held on frustration of contracts. Here to basically discuss, debate, and talk about the future of arbitration. We have Shruti from Delhi. Say hi, Shruti. We have Chinmay from Mumbai.
Hey everyone.
We have Mahesh from Bangalore.
Hi.
And we have Deepak from Chennai.
Hi.
Last but not least, myself, Madhav from Ooty. And if you're wondering why I'm wearing a sweater and nobody else is, I'm 2000 meters above all other cities. Before we start, I just have one question for Deepak and Mahesh. So, if you had the liberty to appear before a judge or an arbitrator in a virtual hearing in just your inner vest, would you consider doing so?
Definitely not.
Definitely not. Not unless we want hearings to be adjourned.
Or even if it's even for it to be dismissed.
Do you think it's going to be a guerrilla tactic?
Definitely a tactic that should not be used.
Ask here is, so have either of you actually experienced virtual hearing in real life? Anyone?
Well, I have, and not just in international arbitration, but also in domestic arbitration. To give you a small example of a hearing that I attended recently, a couple of months ago, was an LCI arbitration seated in Geneva, where one of my witnesses in India was cross-examined through video conferencing by counsels on the other side. And it worked seamlessly, although it went on for a couple of hours, and there were a lot of documents that were showed to my witnesses. I think the reason why it worked seamlessly was because there was a counterpart in the room with us who was handing over the documents if the witness couldn't read the documents that were put up on the screen. And that has, I think, been one of the crucial reasons why the virtual arbitration worked insofar as the cross-examination is concerned. But other interim applications and domestic arbitrations where we've argued from Mumbai to an arbitration seated in England, or a domestic arbitration seated in Mumbai where we were in London and arguing through video conferencing, and those applications have all worked seamlessly for us.
I've had two virtual hearings, not arbitration hearings, but court hearings, thanks to the lockdown period, one before the Karnataka High Court. And I didn't have any problems with regard to the connection because they had all everything set in place with the computer branch keeping in touch with us on a constant scale and passing us all the necessary information. So it was an ex parte hearing, so not much of hassle. But the hearing with regard to the Hyderabad High Court, Telangana High Court, was a bit different because they used a completely different software based out of Cisco. And they, again, it's all about having the meeting ID and everything, but they gave it to us a bit late. But nevertheless, it didn't go on that well because the other side who moved the matter for an urgent hearing had not even provided the papers to the court. So because of which the matter got adjourned. So yeah, it's only a delay caused by the other side, which could not make our submissions, allow us to make our submissions.
Yeah, I'm glad Mahesh and Chinmay's experience were quite good. I had a recent domestic arbitration which was done virtually, and my experience was not so good. Uh, the first 10 minutes of the hearing was like having a call with the family members. Are you able to hear me? Am I audible? Is the mute button on? The mute button off? Is my video on? And after we, in fact, tried to go forward with the hearing, and when things were, I think, possibly were going good on my side, there was a technical glitch and we were not able to continue. One of the participants dropped who were essential for the arbitration hearing, and the arbitration was adjourned and stopped at that time. So my experience was not so good. And in fact, this is one of the crucial things. I think technical glitches is one of the main things that needs to be addressed. And our technical glitches, coaching of witnesses, are they going to be now the new guerrilla tactic in arbitration to stall arbitrations? So, do you have any views on that, or did anyone else experienced a similar circumstance?
I was involved indirectly in an arbitration. So I was assisting the case manager of the arbitration. And the tribunal basically requested that they have a video conference to examine the witness. What happened is the video call kind of consumed all the bandwidth. So the Wi-Fi for none of our laptops, none of our phones worked. So it was an unpleasant situation. I mean, I couldn't work, firstly, and secondly, I couldn't check my Facebook either.
Talking about a virtual hearing, I've had a good and a bad experience. Like all of you said, technology plays a very important role in making it bad or good. And I agree with it. For me, the experience was both ways. I clerked at the Supreme Court, and I remember in one of the matrimonial cases, there was an in-camera hearing. I wasn't a part of it because obviously it's an in-camera hearing, but I know one of the witnesses witnesses are a child. It was something to do with custody, if I'm not mistaken, was based out of the US. So the evidence of the child was taken through a video conference in the Supreme Court back in 2014 or 15. That was a monumental thing, I believe, as per me. In terms of arbitration, I've experienced it in both international commercial arbitrations and domestic arbitration. My experience has been good. So far as the technology was concerned, the technology went glitch-free. But
A few moments later.
The witness was based out of Japan. We had definitely had conferences with him to understand and brief what exactly he's supposed to do. But the first question you would usually be asked is this your witness statement? And to that he said no. None of us were expecting it. He seemed to be on the page the last evening. The witness statement was indeed his. But on the D-Day, probably there was an issue with him understanding the language of the arbitrators or communication gap. But the answer was no. And I wouldn't say more than the fact that the clients had to ultimately settle because of this small glitch, if I may call it.
Yeah, while you were actually talking about glitches, there was a small glitch while you were talking as well.
I have my own issues here.
Taking something forward from what Shruti said, do you think there is a communication barrier which increases when you're actually cross-examining witnesses through video conferencing rather than in person? Like you said, for your Japanese witness, he didn't understand what was being asked probably to him. Otherwise, it's quite unlikely that he would have said that he hasn't signed the witness statement. But do you think that plays a role? Do any of you guys have any idea?
I don't have any personal experience, but I think it does. While Shruti was making a case with regard to the language and how it ended up in a settlement, though it was a good thing for the parties, but I think on a larger scale, a language would be a big problem unless and until if you agree upon, um, a common language to be used for the entire proceeding, whether it's virtual or whether it's for the actual arbitration hearing, which can go on physically. So I think if we can clarify and have a clarity on the issue of language, I don't think we might end up having the same issue. And in addition to it, I also feel another aspect is it's always better to have somebody who's, if a person, say, is coming from Russia or France or Japan, who are mostly tutored or they've been taught only to speak and communicate in their own language. It's always good to have a person next to him so as to enable him to understand in the event it's of course a foreign language to him, in the event he's not able to comprehend what is being told.
Yes.
So I'm going to clarify my example here. There were two translators present. The Japanese client's employee clearly was somebody who wasn't very well acquainted with English, and he had a translator sitting right next to him in the room. We had a translator sitting right next to us, but I think it's probably the warmth that comes in with physical presence, or some amount of mandate that a person feels, or it's just the environment that makes you feel responsible. Yes, I have to listen to something very carefully. I can't get away with it. There'll be people looking at me. So, we can just take an example of a parallel of an exam. In an exam, if you're sitting in your own house, you'd probably not feel as serious writing that exam as much as you'd feel in probably an examination hall, even if you're all alone there.
And yeah, I think when it comes to language, one experience that I've had, or what I've seen, is there are a few companies that provide technological service, that provide live transcript, that provide live translation as well. Even with now, we have Google and other apps where you just basically speak and simultaneously it will translate. So I think when it comes to virtual arbitration, these are certain things that might also come into the picture. It would just not be video conferencing. Think virtual arbitration in itself is a completely different experience. It's like it's like you're in virtual reality, Ready Player One kind of a thing.
So, do you think we are increasing more hassles by going virtual?
I would like to say sort of, yes. For me, what I feel is there is this paranoia, due process paranoia with virtual arbitration. We are assuming witnesses will be coached. There would be guerrilla tactics if it's virtual arbitration. It's so much more easier. Nobody's basically monitoring me. So I just feel once that gets in, the entire process in itself becomes rigid. I mean, arbitration is what we know it as. It's flexible. It's just basically informal. It's a bit more informal than court hearings, and I think that might just get lost in the process.
I think it is we are just opening a semi Pandora box in terms of having more hassles and everything. But I think technology by itself, at any point of time used, the concept of improvement always comes with certain issues which we'll have to be dealing with. Like for example, Madhav at the beginning mentioned very clearly that a video conferencing consumed the entire internet which they had. So probably that will lead to a different scenario where the arbitration centers or each one of us will have a better network to be using. I mean, for us to be using to cover the video conferencing, and even the applications will become much smarter in terms of allowing us to consume less data while giving up the same output. So yes, it is a hassle, but as we all know, uh, at the beginning, any technology would cause a problem. But while we get into it, we get used to it, and we actually develop solutions to cater every single problem. So I don't think it would to start off, yes, but not to go.
I actually
Not
agree. As always, with passage of time, technology definitely improves. And in fact, I recently came across a webinar where one of the speakers actually drew an analogy between demonetization and use of virtual hearings, where during demonetization, even though most people found it hard to use cashless at the beginning, over a period of time, even after the cash was available in plenty, after a period of years, people still use Paytms, Google Pay, and other modes of cashless transactions. So maybe at the initial stage, even virtual hearings, since we are all in the testing time in the COVID crisis, we might find it difficult to use at the initial stage. Most of us are new to it. Uh, During in a passage after a particular period of time, I'm sure the technology as such will definitely improve to cater the needs and essentials of arbitration hearings, the hits and misses, and I'm sure everything should be worked out in future.
I think what everyone's coming to here is a need for a mindset change of practitioners, of arbitrators, clients to be able to view virtual arbitration as a certain possibility, as a medium to adjudicate disputes and not just physically present before the arbitrators. if there is a mindset change, virtual arbitration certainly has qualities that are worthy of consideration and certainly worthy of being a permanent solution than to actually travel physically to hold hearings. But until such time as there is a mindset change, and until such time as procedural irregularities or inability to sort of make your case in a virtual arbitration would be held as potential grounds for challenging an arbitral award under due process or for refusal of enforcement. If until that mindset doesn't change, I don't see virtual arbitration being used as a permanent setup.
Even me and Deepak just today we were mentioning about how emergency arbitration could actually be more. I mean, how virtual arbitration could be a thing for emergency arbitration and urgent matters. And in fact, that's what we've been seeing in Delhi High Courts and also in the Supreme Court, where you have to just make a concise presentation, because it's an urgent matter, so you do not face too many difficulties when it comes to video hearing or virtual hearings. So I
I
think
think this is, sorry to cut you there, but just to make a point, that I think this is precisely why the ICC rules say that specify video conferencing only for CMCs, case management conferences, emergency arbitrations, and expedited procedures, and then has a very general clause that the arbitrators can conduct proceedings in whatever way possible for other kind of hearings. But as you were saying, I think it's virtual arbitration is more doable for CMCs and interim applications or emergency arbitrations as opposed to full-fledged trials.
Yes, I think because most of us agree that the complications arise when during cross-examination of witnesses. Basically, arguments as well as representations can always be done virtual. The problems might arise when you have witnesses from other countries or other states, and when during cross-examination, are they being coached or not, as Madhav mentioned. Yes, I agree with you as well.
I just want to share an example, and this example is based on some experiences that I've had while organizing events at an arbitral institution. So, say that you have Shuri from Wakanda, Africa, who is expert in vibranium technology. It happens to be so that she is also a fellow in CIR. Vibranium technology has become popular. China is investing a lot on vibranium technology, because of which you have a lot of contracts that have an element of vibranium technology. So, and I invite her for an arbitration conference, which she accepts. Eventually, what happens is that because of some visa issues in the last moment, she cannot attend the conference. And I have to basically rely on the usual suspect, that is Tony Stark. Now, let's say this was entirely virtual. So this event was virtual, or rather this event was using some virtual technology. In such a scenario, then Yuri could have participated irrespective of her visa issues. And this is where I feel that somebody who is a female, an African, who is young, and who is also not a lawyer could actually be considered as an arbitrator because of virtual technology. So, I mean, this is basically the scenario that I would like to present and either agree or counter this. I mean,
I mostly agree with you. But first of all, you do know that Tony Stark is dead, right? So you cannot call him an arbitrator.
Considering the point, which I think, yes, I think diversity would help us, help that young lady from Africa to be an arbitrator. But there's one concern I have with regard to diversity. If the arbitrator is not able to understand, what you are proposing is that giving an opportunity to an arbitrator to be a part of a hearing, but I am looking at diversity from the arbitrator to the parties. Like, say, the reverse example: a person who's coming from a developed side of the world, and there's somebody on the other side who's from a developing country or even underdeveloped country. So, what would be the situation if he's not able to understand the kind of language he or she would be having, the accent or the vocabulary which you're talking about, and three, what if they are having an on and off problems with the internet? So, I think diversity would also be accounted from both the sides.
Yeah, I agree, because So when you talk about diversity, you always go to what so-called lesser developed countries having arbitrator pool from those countries. But again, as we already spoke, due to lack of technological advancements or various other constraints, it might be difficult from that part of the world to actually go for virtual arbitration hearings. In fact, the Wismut which happened this year was completely virtual. While many anticipated that diversity is not going to be a barrier this year, cost is not going to be a barrier this year, students from across the world can come and participate. I think the participation significantly decreased from the lesser developed countries, mainly because of technological issues or something else. I'm not sure why, but definitely that's going to be a problem.
I quite agree with Deepak because if you look at statistics and if you compare India with other developed countries, India has about 40% of connectivity. And if you look at numbers, that's quite a bit of Indians who have access to data. But when you compare it to other Asian countries like Singapore or Thailand, which has about over 95% of people who have access to internet and connectivity, then India's numbers are dismal. And therefore, if you're looking at diversity insofar as having people from lesser developed countries be a part of your arbitration, then technology does play a significant part, and these numbers are not very promising.
What we're saying is basically now access to justice will depend on access to technology, good technology.
Yes. Yeah. So I think even yeah. So though I feel that diversity might be enhanced, yeah, I think there is a flip side as well from what I figured from your discussion. I mean, what if you have a developed place like a London or a Singapore or Hong Kong with better internet connection, and then eventually you would have arbitrators concentrated from these areas nonetheless. So, so
Just
yeah.
another question, talking about diversity, what about cultural diversity? You initially asked this, are you okay with attending court hearings with bunions? Will you be okay with attending arbitration hearings with bunions?
I mean, if I have a good physique and if I want to intimidate the arbitrator, I can just flex my body.
In fact, just talking about the Rajasthan High Court judge, I also read an article which talked about a Florida judge a couple of weeks back or a week back, whereby a similar circumstance happened in Florida as well. The judge especially even mentioned that lawyers were in fact under covers from their beds arguing their cases, and he found that not agreeable. So you never know. Something
I mean,
which might be culturally acceptable in some countries might not be so in others. So cultural
yeah,
diversity might be
I,
another.
I, I guess I guess then it comes to the point of mindset eventually. I don't think technology would help. I think
One thing that concerns me is we're probably losing sight of the actual user. What does the user want? What does your client want? In small arbitrations, probably the client will be happy to let go of the costs of flying you down and getting everybody into one room, accommodating them, paying so many people. But when you talk about really big arbitrations involving a lot of underlying value, I don't think the clients would really appreciate, and probably they prefer everybody comes together, stays in, like, let's say, war rooms for some time and picks up everything in their matter and really gives it their best and in person solves it for them. Uh, are we losing the sight of the client's idea behind it? It's definitely good. Virtual arbitrations are great, but why not have them in person if the client can back it?
yeah,
So it's a very good suggestion which you, rather the point which you brought up. But here, I think a virtual hearing is what we are discussing as an option, which can be incorporated within their agreements and everything. And in the event, if they want to have a physical hearing, they're free to have it.
yeah,
But the concept here is with regard to what if they want to have a virtual hearing in a situation like this, where no fly, we cannot go from country to country. So then what? What is going to happen? I was even reading upon an article which said an ICC arbitration was concluded over Zoom or another equivalent application because the parties could not wait. Again, consideration of the parties.
Yeah, I agree. Yeah. In fact, still, we also have to appreciate the fact that we are still at a very nascent stage of virtual arbitration here. Most parties do not use virtual arbitration yet. So, over the years, in time, probably the parties will want to use virtual arbitration. Even if you have an option, even if you have the money, even if the stakes are high, for you to conduct an arbitration in person, if virtual arbitration is seamless and easy to use, parties may choose it in future over personal arbitrations.
Example from a recent arbitration. Now, this arbitration Singapore seated because of the COVID scare. The arbitration's venue was shifted to India. Now, the filing's been done, written submissions have gone. Now, the second stage of oral hearing, which is somehow very peculiar to this case, is supposed to happen. Now, why it's not happening is because all the councils representing one side are based out of different cities. Now, somebody's based out of Bombay, somebody's based out of London, the other one's based out of Singapore. Now, they can't really represent and brief each other in a live hearing. The problem they're facing is how me as a second chair brief my first chair so that he can talk about the case to the arbitrator or explain the case and argue it on behalf of the client. And the client's also not comfortable because he doesn't have all the lawyers in the same room. What if something goes wrong? What if the other one doesn't really know what the case is all about? So he wants the entire team to sit in one place and then have the virtual hearing.
So briefing senior counsels will always be a problem during arbitration.
Couldn't you do it virtually?
Very
Virtually.
difficult.
How do you do it virtually? If you're not next to the senior counsel making a point, then how do you make a point when you're actually just two rectangles on a screen?
You could just type it out.
So Chinmay would remember in one of the arbitrations we were on the same side. There were times when the cross-examination is happening, and I probably read the brief a little carefully than everybody else because that was my specific part, and I know he's lying. I pass a chit so that the person who's cross-examining can actually ask that question, put it to its face, and really crash the credibility of that witness. How do you do it in person? Do you WhatsApp? And what if the
I think there are platforms like even in Zoom where you would have separate rooms. So the council of one side would have a different room that they would be in, and they would basically have a chat feature where, as a counsel, I could just type that the other person is lying.
No, I agree with that. But what if that's not simultaneously? That's actually not.
That's what I was about to say. That's going to be much slower anyway, because we actually even whisper in senior counsel's ears in India when they're speaking. So that actually happens. So
How does an arguing counsel know when to look at the chat box or if somebody's typing something that is relevant while at the same time he is addressing the tribunal?
true, because I even when Shruti was typing out messages, I noticed that she was typing some messages only after the sixth message. So you might lose track of other things when you are actually in focusing on discussing a particular topic.
And even the other part which would come into play is how well will you be equipped with technology to understand it simultaneously while we are actually doing another work that's arguing a matter or cross-examining somebody. I think while you're cross-examining, you can actually interfere and you have some time to look at your chat box, but not while you're arguing the matter. Because the flow in which you would be going would be completely different, and it coming to it and going back and seeing if normally also when we're arguing in the court, if somebody is trying to pass a chit, even the senior counsels, most often they don't even look at it. So we need to pass the chit 3-4 times. They take the chit, they keep it under their brief.
Probably
Or they
not
keep it.
to make sure that they see a chit. That cannot be done.
Yeah.
That gives more autonomy to the arguing counsel.
So I think this problem which Shruti did mention, present lockdown specific, but going forward, I don't think it would become a big issue because I believe that it should be the case where all the counsels should be sitting in a particular room while I'm talking.
Basically ask, so what about confidentiality? Is there going to be an issue of confidentiality, firstly? And do we see a solution here?
Well, insofar as confidentiality is concerned, certainly consent of the parties before starting the procedure would certainly take care of any breach of confidentiality and recording of proceedings by parties are concerned.
So, so far as the issue, whether it's an important issue Yes, it is. In fact, I would term it a very serious issue. So, for me, having said that it's a serious issue, I think a solution for that would be probably adopting a secured system by the arbitration center itself. Like, for example, ICC uses this particular case management software called Netcase, which would allow everybody to, exchange their documents, their emails, and everything. Likewise, if they're able to come up with a video conferencing facility as well, that would solve the issue of confidentiality. That is one solution I can think of. The second solution is uh, probably these arbitration centers can set up centers, which I would be calling it as command centers across the globe, where parties would be present. Like for example, if I'm in India and I want to like have it to the command center maybe in New Delhi or Bombay, and there they would be having their people as a venue observer to look at it if everything is going on fine and whether the witnesses are being tutored or not. So these are the two. One is a software oriented solution, the other one is man management. So either of them can be used, but going forward, I think only the first solution will succeed and not the second one.
That's actually an excellent and novel idea. Having command centers in different places. That will definitely eliminate the downside of probably confidentiality issues when each person will be using their own places and video conferencing facilities to go forward with the virtual hearings. We are not sure whether they are being recorded or there's any confidentiality breach as such. But I think probably the downside is that again, if you're going to invest this with arbitration institutions, do the parties as well as the councils and arbitrators have to go to the respective arbitration centers again? Will it actually render the entire virtual arbitration moot? Because again, you have to go to a particular place to conduct your hearings. Anyone else have any view on that?
I mean,
I think it would increase costs to some extent of the parties. So the whole idea of reduction of costs in case of a virtual arbitration will not really be one of the advantages if you add all of these additional expenses to take care of the disadvantages of virtual arbitration.
I agree, as well as probably the universal application of it. If what Mahesh says, command centers are going to come up, consensus of worldwide consensus has to be in place, whereby all countries will have to put up command centers of their respective arbitration institutions.
yeah,
So
yeah.
that's
So
going to be a big
for me,
problem.
actually, coming from an institution, I mean, having experience from an institution, the problem that would eventually arise is which institution would take it. Because I think there's a lot of competition among arbitral institutions right now. In fact, while I was in an arbitral institution, the first thing we used to do is go look into the clause, see if it's the arbitral institution, that is our arbitral institution, that is mentioned clearly. Because if not, there are other arbitral institutions, they eventually have a problem saying that how is it that you took jurisdiction of this case, unless in your contract, in your clause, you specifically mention that you would be using virtual hearings using this particular arbitral institution, and that particular arbitral institution has a center in one of the cities in the country, or probably in all metro cities, then maybe it could be a possibility. But then eventually there should basically be a model clause introduced by the arbitral institutions to make that happen. You need to have clauses included in the contract for that. So a lot of, I think when it comes from an arbitral institution perspective, I just think the execution might just become a bit difficult.
Yeah, I think when we talk about internationalizing and uniform, like having a uniform system, do you think something like a New York Convention would help you? Like New York Convention or an X Convention on, technology democratization of international collaboration.
I think that could be the issue. Only again, what's going to happen. So one thing that I realized after the New York Convention did come into force is that arbitration in itself became too legal. and it was like you had arbitration rules come out so frequently. So you had the New York Convention, and then you had arbitration rules and arbitration legislations just based on the New York Convention. Even I think even for the Singapore Convention, Convention on Mediated Settlement Agreements, it could just be a situation where you have mediation rules, which would again make the mediation quite rigid. I mean, arbitration started off as a flexible process; it's become very rigid now. A lot.
And another downside probably for having command centers in conventions is conventions have to be on general laws. It cannot probably specify which arbitration institution is going to be a command center in respective place. So you can actually formulate the general rules as to how to do an arbitration virtually, or how an arbitration institution can support a virtual hearing. But as such, you cannot include the specifics in a convention. That might be another difficulty. So I'm sure it should be again vested with the inside the commercial contracts. When parties sign, they have to. I agree with Madhav. You have to probably include a clause which specify specific arbitration institutions. That must be the way to go about it.
And I think another convention on virtual, so then you need to start interpreting each clause in by itself to actually even find out whether it's a virtual arbitration. So
that's why we guys are there. We'll
Well, at the moment, we do have the Seoul Protocol on international arbitration for virtual hearings, and I was just going through those before our conversation today. And what I realized is that in one of the articles, they really specify what kind of internet bandwidth that's required if you're having a virtual arbitration, the kind of the requirements that are when you should have technically as well as physically if you're going to use those rules for a virtual arbitration. And sometimes I think that if you actually apply those rules as soft law like you do for IBA guidelines, then it really ensures that your arbitrations becomes far more rigid in practice. What about places where you can't apply any of those rules and specifications, but you can still have a regular video conferencing facility, and if that helps your arbitration and if it works for you to undertake an arbitration seamlessly, then do we really must follow all of these guidelines?
Guidelines are, like you said, guidelines are supposed to not be followed to the T. They're supposed to just give you an umbrella. This is what you need to do.
They're just like a tour guide.
Exactly. Like, these are great, but if you don't have time, you can miss these too.
Exactly. I mean, you just get lost in that, though.
I felt these protocols should be followed to the T. And in addition, what these protocols did miss is the encryption. That's because at the end of the day, if we are not able to spend for setting up an exclusive software, we would be using a third-party cloud server like the one which we are using now. If the encryption is also set to a particular standard, probably that will also help in terms of protocol being much more helpful. But these protocols, considering the motion, these protocols must be read with whatever the arbitration guidelines or the rules of the centers are. Like in one of the article I was reading, that London Court of International Arbitration has a clause in itself which allows virtual hearings for everything, like starting with pleadings to the final hearing, cross-examination, everything. However, for ICC and ICBR, they have it's restricted only to emergency hearings. So I think going by that perspective, I would feel protocols must be enforced, or rather it would be enforced in a greater deal, like just the way IBA guidelines and other things are now looked at, and even New York Convention.
So I guess that concludes our debate and discussion. I hope it was fun. Well, I definitely did have fun.
I learned a lot.
Yeah, I guess a lot of the viewers would also learn a lot. If you want to know more about the panel, I think you can Google us. We are quite popular. Or you could basically connect with us on LinkedIn. So with that, I would say adieu. So I guess everyone does.
See you. Stay safe.
Yes.
Stay safe, everyone.
Yes,
Take
stay
care.
safe, stay
Yes.
home, and watch this video. It's quite long, so I think it will help a lot of people not to get coronavirus. So, would you prefer that arbitration practice goes virtual? Let us know in the comment section below. And if you have any questions or if you would like to introduce any topics, you can use the comment section for that as well. We really hope that you enjoyed the discussion. And if you want to be notified for our future discussions, you can subscribe to our channel. We really wish you well, and until next time, goodbye.